Morning friends, it's a bright Sunday morning. I have filed my reply to the defamation suit in Bombay High Court yesterday, and I am going to read that reply or important parts of that reply today. And one of the main things that I want to focus on is how Lodha basically puts a cloak of silence not only on journalists like me, but also on buyers of the flats and customers. How he ties them in a way that they cannot approach courts, that they cannot speak in public, etc. So I'm going to read significant parts of my affidavit in reply to you. It's not going to be the whole of it. There will be many parts that I will read to you later on in other videos, but I'm going to read one major part of it now. I, Krishnaraj Rao, aged 53 years, working as a freelance journalist, a social activist and a consultant related to real estate issues, residing at 501 A Wing, Raheja Green, Raheja Estate, Kulupwadi, Borivali East, Mumbai 66. Do hereby solemnly affirm and state as under. I'm going to skip this first paragraph, go to the second. At the outset, I say that the present proceedings filed by the plaintiff is false, frivolous, vexatious and mischievous, and has been filed with ulterior motives and with the sole aim and intent of suppressing and silencing me in my capacity as a public-spirited journalist, and also the defendants who have aired their genuine grievances as flat purchasers in the new Cuff Parade project, hereinafter referred to as the project of the plaintiff. I say that the present proceedings are an attempt on the part of the plaintiff to arm twist the defendants and unleash a reign of terror among journalists and flat purchasers into quietly accepting the flats and the projects on an as-is, where-is basis without dissent, protest, or even fair comment and criticism. The plaintiff seeks to cloak the present matter with the garments of a private citizen's right to reputation. Although the present matter pertains to an activity that is widely advertised and has great relevance and bearing on public safety and welfare, I submit that any widely advertised activity of the nature of the present matter, which is advertised, cannot legitimately seek the protection of the court. I submit that if a project or activity is advertised for sale and solicits public investment as well as government permissions, it is intrinsically public in nature and it cannot seek to be exempt from criticism under the cover of a defamation suit. I submit that the suit ought to be dismissed in limine with compensatory costs for this reason alone. For these reasons alone. Further, I submit that what is depicted in the impugned articles and videos referred to in the suit is a fair comment and criticism of the project, and that granting of any of the reliefs prayed for by the plaintiff will have the effect of denying the defendants their fundamental right of free speech and expression, which is guaranteed to them by the Constitution of India. I submit that the suit ought to be dismissed in limine for this reason alone. Further, I say that the plaintiff has suppressed several material facts from this honorable court and has come to this honorable court with unclean hands, and on this ground also the above suit is required to be dismissed in limine with compensatory costs. Now, guys, I am taking you into confidence on this suit because I consider you to be participants. Many of you have actually contributed small or large amounts towards the cost of the suit or towards helping me with this cause. So I consider you all, the public, to be stakeholders, and I also consider you to be stakeholders because this relates to you. It is it is not just a case between me and Lodha. It is not of a private character. It is actually pertaining to whether a flat owner can criticize a flat that she has actually gone and purchased and taken full possession of after taking full payment. Also, it relates to whether a journalist can criticize a real estate project or even any product for that matter based on its actual shortcomings, which can be demonstrated in videos. So there is a lot of public significance in this case, and therefore I consider it legitimate and actually necessary. I consider it my duty to share all this with you. And now I'm going to continue reading. Now this is the part where I'm going to start talking about the cloak of silence. First, I'm going to speak about how and why and with what research I wrote about the Lodha New Cuff Parade project and made videos about New Cuff Parade project. So, point number 5. I state that I first became aware of Lodha New Cuff Parade project at Wadala when defendant number 2, that's Shilpi, approached me on or around September 22, 2018 and briefed me about many issues with her 2 flats and the overall project. First site visit. I took an independent site visit on October 14, 2018 by telling the plaintiff's sales team, that is Lodha's sales team, that I was interested in booking a flat. At the project site, I was shown a random furnished flat belonging to some other homeowner, and I observed many qualitative and safety issues and shortcomings at first hand. Now remember, this was without Shilpi or anybody else accompanying me. I went by myself with the sales team. I insisted on going to an actual flat, and I was shown an actual flat. Second site visit. On 15th October 2018, I met with 2 other flat owners introduced to me by defendant number 2 and also with an architect, and along with them and other homeowners visited many other flats in the project in order to observe the shortcomings and deficiencies of the flats and the project. In this visit, I did not take any videos. First reason is that this happened after dark. So while we were looking at this place, these places, these different flats, I could not, it was not a very good environment for taking a video. And secondly, I did not want to get in the way of the architect. So I was really quietly observing from the background, but I observed a lot of the deficiencies and I was shown a lot of the deficiencies of the flats and the project. Indeed, I was an active participant in showing the architect, pointing out to the architect many of the deficiencies. Third site visit. Along with defendant number 2, that's Shilpi, I visited the project site and the flats belonging to defendants number 2 and 3, Shilpi and her husband, on October 14, 2018. And we shot the impugned videos and photographs and made many more observations regarding quality issues. Meeting with other aggrieved homeowners on the project. Now, not only I met with Shilpi, not only I met with those other few people who showed us their flats. Some of the flats were lived in, but I also attended a meeting of these homeowners, which was held at a hotel on a Sunday. So, meeting with other aggrieved homeowners on the project. On 28th October 2018, I attended and addressed a formal meeting organized by many other aggrieved homeowners. I interacted with many homeowners who were agitating their matters before various legal forums, including RERA and the High Court, and I understood the issues and the proposed remedies from their perspective also. I prepared the article and the videos over the next 10 days but did not publish them. Okay, so it was not something made and published in haste. On 8th November 2018, I emailed the draft article, which included the videos, to the plaintiff, that is, to Lodha. Email IDs of many of its topmost officials. I emailed to its top people, including Abhishek Lodha, for rebuttal or rejoinder, as was and is my standard practice. I received no response. Again, on the morning of 12th November, when I was about to publish, I sent the plaintiff a reminder requesting rebuttal before evening. To these emails, I received no response. I did, however, get an automatic response from the email ID of Mr. Abhishek Lodha, CEO, stating that he was not available, and in case the matter was urgent, email should be addressed to one Miss Jasmine Bilimoria. Now, I had already sent this and I resent it again to Jasmine Bilimoria. Accordingly, I sent emails to Miss Jasmine Bilimoria but received no response in any form whatsoever. Thereafter, having thoroughly done all due diligence from my side to ensure the accuracy and veracity of my article and videos, I went ahead and published the impugned article and videos on 12th November 2018. There was absolutely no response for the same for nearly 2 months. That is until 9th January 2019. From 12th November, 12th December, nearly 12th January, there was no response. Now, on 9th January 2019, we received a legal notice from the plaintiff. Now, the initial lack of response and a belated response from the plaintiff by way of a legal notice and subsequent suit appears to have been actuated by a cynical attitude of habitually and intentionally suppressing and cloaking with silence all discussions and concerns raised regarding the quality of their products, their services, and their financial conduct with customers. I have had interactions with many customers, people, and the usual response that is given by by most or in most of the correspondences is a stony silence. The matter is usually de-escalated is responded by sales team or by CRM, never responded by management. In my case, there was no response from anybody. The plaintiff issued the said notice on 9th January 2019 only when it became abundantly clear to the plaintiff that this cloak of silence tactic was not working due to the compelling clarity with which I, along with defendant number 2, had highlighted the various shortcomings of the flats belonging to defendant number 2. Okay, remember, keep in mind, we highlighted the shortcomings of the flats that actually belonged to, were owned by and possessed by Shilpi Third and her husband. They were within their rights to criticize a product that they purchased, that they owned. When I broke the walls, it was not breaking the walls of Lodha's flats, it was breaking the walls of Shilpi Third's flats. It must be pointed out that the standard operating procedure of the plaintiff, Lodha, is to prevent the potential customers and even customers who have paid a large proportion of the purchase consideration from actually entering the actual flats, whether their own or somebody else's. For this reason, the actual build quality and architecture of the flats in this project were an area of complete ignorance for potential customers and even for customers who had paid 100% of the consideration amount plus additional charges. Okay, people who have paid 100% of the consideration amount, they may have paid 3 crores, 4 crores, 5 crores. entire amount, and they may even have paid parts of the maintenance charges, even they are not aware of the actual build quality and architecture of the project. They are kept in complete darkness. Even after part occupation certificates were received, that's the part OC, the flat buyers were not allowed to enter and examine their own flats. Or, at best, they are allowed only under strictly controlled conditions, which are not conducive to a close examination and clear understanding of the product. You're not allowed to just walk around freely in the flat that you paid 100% of the consideration amount for. That is what I'm saying. Their CRM, their people will always be right behind you. And this has been experienced by many customers. Moreover, even flat buyers who have paid 100% of the flat value are, as a matter of standard operating procedure, prevented from seeing and entering their own flats. And forget about entering the flats, even the towers in which their flats are situated. Now here is the crux. Until and unless they sign a waiver releasing the plaintiff of all legal liabilities and possibility of claims arising from the shortcomings. These waivers, as mentioned above, are marked and annexed as Annexure A. Now I am going to show you the specimen of a waiver. The fact that the plaintiff seeks such waivers from the purchasers is a testament to the fact that the plaintiff is admitting that the product so advertised and sold is substandard. My articles and videos broke this cloak of silence and brought the plaintiff's wrongdoings to light. The present defamation suit is a belated and frustrated effort by the plaintiff to suppress the true facts from the buying public and also the government agencies that are regulating and licensing these activities. Now I'm going to show you the waiver, okay, and I'm going to take you to this. This is the thing that I have filed. This is on page 340 of the plaint that I have filed before the Bombay High Court yesterday. Okay, here is a specimen of one of the waivers. Now the waiver is written as if you are writing a letter. You the buyer, you the flat purchaser, are writing a letter to Lodha. But this is the format that is given to you. The date, August 2018. To Lodha Developers Limited. Okay, I'll increase the width of this slightly so that you can see the whole. Yeah, there you are. To Lodha Developers Limited, Lodha XLS, Apollo Mills Compound, NM Joshi Marg, Mumbai 400011. Now, dear Madam, regarding unit number dot in building shown as Lodha dot building at New Cuff Parade, agreement to sell dated dot in respect of unit bracket ATS. Okay, ATS is agreement to sell. Now remember this, they are calling this agreement to sell. There is a legal difference between agreement to sell and sale deed. And this is another area where they are causing confusion, and this is deliberate. I would have thought that confusing the agreement to sell with sale deed or sale agreement is an innocent action by most builders. Maybe it is, I don't know, but in this case, this is a very calculated, very cunning wording. Agreement to sell, dated so and so in respect of the unit. Now, An agreement to sell, by the way, only indicates an intention to sell. It does not indicate the sale itself. And this is a tactic. Now let me read the letter format which you are supposed to sign. We have entered into the above agreement to sell and pursuant thereto, taking possession of the unit on or around such and such a date. We are aware and understand that on account of various issues, including regulatory issues relating to height approvals, the project has faced significant delays due to factors beyond your control. Now, Lodha is not saying it is beyond his control. You are saying the project has faced significant delays beyond your control. Okay. Lodha is not admitting, according to this letter. You are saying it. You, the buyer, are admitting that we know that there are significant delays due to factors beyond your control. And there have been disagreements on certain aspects of the design of the unit stroke new cuff parade. Unit new cuff parade. Okay. We also understand that the final permissible height of the building was communicated to you only in early 2018 and the works being carried out at terrace level are pursuant to such communication. So let's understand the implication of this. Lodha is, first of all, trying to avoid admitting that he did not even have the final permissible height of the building until early 2018. But he sold you the flats. Okay? You do not know how tall a building is going to be. The builder does not know how tall the building is going to be, but he sells the flats to you nevertheless. What is this? Is it not deceit? Is it not cheating? Is it not fraud? But let us go ahead. Here what you are doing is you are supposed to be giving him a clean chit. We also understand that the final permissible height was communicated to you only in early 2018 and the works being carried on at the terrace level are pursuant to such communication. While we do acknowledge that works are being carried out at the terrace level are due to factors beyond your control, this has, however, caused inconvenience and hardship to us and the occupants of the building. Now, this may look like, hey, listen, the builder is actually, samne se, he is acknowledging that it has caused inconvenience and hardship to you and to the occupants of the building. But what is he doing? Why is he doing this? In the light of the aforesaid and the inconvenience and hardship faced by us and pursuant to our discussions, we hereby agree and accept a sum of rupees blank special discount as a full and final settlement of all our claims and disputes of any nature whatsoever, if any, against you in regard to the unit and the project New Cuff Parade and or under agreement to sell. This special discount will be received by us in the following manner. This many rupees by check number such and such, dated on the same date as the date of signing of this letter. So first you will sign the letter and then he is going to give you this check. So many rupees dated 31st October 2018. Now keep in mind that this letter was written in August 2018. So 2 months later, he is going to give you another further amount on 31st October 2018. And this many rupees, Indian rupees dot, to be paid by check number dot, dated 30 June 2019. That is how many months? August, September, October, November, December, January, February, March, April, May, June. 10 months, I think. With the understanding that you will arrange. So what he is saying is that you are going to be paid in phases, but you will have to sign this waiver letter right at the beginning. Okay? 10 months before your last check will be honored or even not honored, even if it is dishonored. If he has given you even one check which is honored, you are bound by this commitment, irrespective of whether he is going to respect and honor the other two checks. Okay? If you have to, if he doesn't honor the other two checks, if he bounces the other two checks, and by the way, this is a really paltry amount. What you are offered is a total of around 5-7 lakhs. Consider what a paltry amount this is, because your flats are worth 2.5 lakh, 2.5 crore, 3 crore, 5 crores, I don't know, 7 crore, maybe more. But you are offered 5 lakhs, 7 lakhs, some such tiny pittance. And what are you doing? You are waiving. You are saying that this has caused inconvenience and hardship, and the ongoing work has caused hardship, and you are accepting this tiny pittance of an amount to let him go. Now then, what are you saying? This much, the Indian rupees, this much will be paid by check number such and such, dated 30 June 2019, with the understanding that you will arrange to obtain the final occupation certificate, OC, which means you are now acknowledging that the building does not have OC, and complete and hand over the operations of the buildings to the society by this date. Now, as soon as he hands over the OC, he is also going to hand over the possession, the operations of the building. In the event the OC is received and handover of the building to the society is completed prior to 30th June 2019, you will replace this check with a check dated the same day as the day or date of handover of the society, and will hand over the said check concurrently with handover to the society. For the avoidance of doubt, it is clarified that in the event the OC is not obtained by 30th June 2019, IV will be entitled to encash the check. Okay, so till then you are not okay. In such an event, as and when OC is received, the handover of the building to the society will be deemed to have occurred on the date of the OC. So even if he is late from the date of the OC, it will be deemed that the building was handed over to the society on the date of the OC. Now, what does that mean? It also means that from that date onwards, if you have a litigation, if you are going to complain about the quality, that complaint will have to be filed against the society, not against Lodha. That is the meaning of this phrase. In such an event, as and when OC is received, the handover of the building to the society will have deemed to have occurred on the date of the OC, even if there was no society existing, even if the society was later on handed over, it will be deemed to be handed over on the date of the OC, meaning that you will now have to litigate against the society, not against Lodha. We declare that all notices, letters, complaints, applications filed by us and or claims and or objections raised by us before any authority or court are withdrawn and are deemed to have been withdrawn forthwith. Okay, if we have complained before any authority, the date of this, when you sign this letter, even before you actually withdraw the complaint, these complaints are deemed to have been withdrawn forthwith, immediately, the day you signed this letter. I also acknowledge the receipt of the checks referred to at A above, and you confirm that the aforementioned checks, when presented for payment, shall be honored. Yeah. You confirm. Okay, now there is no confirmation yet. You, the buyer who are receiving the check, are saying you confirm. So he is not bound by your statement. Keep that in mind. Further, in case any proceedings before any court, tribunal or authority are commenced or have been commenced or are ongoing in connection with the unit, we will file the necessary applications to have such proceedings unconditionally withdrawn at the earliest. So you are tying your hands and feet. For the avoidance of doubt, it is clarified that notwithstanding the acceptance of the special discount, You shall continue to be responsible and liable for any defects in respect of the unit in accordance with the provisions of the ATS. Now this letter gives you, this last paragraph gives you comfort. When you are signing this letter, if you say, hey, wait a minute, what about if there is any defect? It gives you comfort. It gives you the comfort of saying you shall be liable and responsible for any defects. But please keep in mind, unless and until the builder says we shall be responsible and liable for any defects in respect of the unit with the provisions of the agreement to sell, he is not bound by your paragraph. Lodha is bound by his paragraph. You are bound by your paragraph. You are bound by this last paragraph of this letter. Lodha is not bound. Lodha Developers Limited is free. Keep this in mind. These are all legal tricks. This is the kind of letters with which they have tied your hands and feet in a waiver. And therefore, what I am saying once again, I have put this waiver in my reply to the plaint. The fact, I am stressing it here, the fact that the plaintiff seeks such waivers from the purchaser is a testament to the fact that the plaintiff is admitting that the product so advertised and sold is substandard. My articles and videos broke this cloak of silence and brought the plaintiff's wrongdoings to light. The present defamation suit is a belated and frustrated effort by the plaintiff to suppress the true facts from the buying public and also the government agencies that are regulating and licensing these activities. And may I add, from the entire journalistic community. This defamation suit is an effort by Lodha to scare the entire journalistic community, which would otherwise be looking at his projects very, very, very closely and criticizing it. So guys, I'm going to read you more from my affidavit of reply, but for the time being, this is enough. Thank you very much. Have a fantastic Sunday.